The Supreme Court has just triggered a constitutional earthquake with an emergency ruling that could eradicate firearm permitting mandates nationwide forever. The century-old regime of state-controlled access, defined by invasive background checks, exorbitant fees, and bureaucratic delays, is effectively dead. This isn't just a regulatory change. It is the termination of the era where you needed a government permission slip to exercise a fundamental right. If you care about the survival of your constitutional freedoms, you need to understand the magnitude of this shift immediately. The High Court utilized the emergency docket, the venue reserved for genuine constitutional crises, to deliver this shockwave. While thousands of cases die in the appellate pipeline, the justices used this mechanism to signal that irreparable harm is occurring right now regarding gun rights. This is not the standard judicial path. Emergency orders are deployed only when immediate intervention is required to stop executions or enforce federal mandates. This is a command, not a suggestion, and lower courts must comply immediately. There is no negotiation period, no phase-in window, and no room for state-level resistance. Just as they did with voting rights, the justices are reshaping the legal landscape overnight to halt ongoing violations. This signals a calculated permanent dismantling of the permit infrastructure by the highest court in the land. Consider the chaotic reality for the million Americans currently holding concealed carry permits. Decades of compliance, collectively amounting to thousands of dollars in fees, rigorous training hours, and months of waiting for bureaucratic approval, may now be legally worthless. These citizens followed every rule and paid every extortionate fee demanded by the state. Now those permits are potentially invalid, not because of criminal activity, but because the Supreme Court has flagged the entire licensing apparatus as an unconstitutional infringement. Whether you are a Texan who paid a nominal fee or a New Yorker who navigated a police interrogation and notarized character references to exercise your rights, your permit is now a relic of a failed system. A massive legal void has also opened regarding reciprocity. The current system allows permit holders to travel between states based on mutual recognition agreements. If the permit itself is illegitimate, the interstate agreements based on them collapse immediately. This raises a critical question. Does this ruling trigger automatic national constitutional carry, or will states weaponize residency requirements to arrest travelers? This is a developing legal trap for millions of gun owners attempting to cross state lines. We are witnessing the implosion of a billion-dollar bureaucracy. Gun owners have been bled of over $1 billion in permit fees alone over the last decade, excluding the hidden taxes of training costs, fingerprinting, and lost time. Restrictive states like California, the cost of admission for a constitutional right, hit upwards of dollars per person when factoring in all mandates. This created a parasitic industry of processing centers and administrative staff whose jobs existed solely to manage the permit pipeline. That infrastructure is now constitutionally toxic. States are facing a tidal wave of class action lawsuits demanding refunds for fees that were collected under an unconstitutional pretext. If the courts confirm that permits were illegal ab initio, then every dollar collected was theft. New York and California are staring down billions in potential financial liability for what essentially amounts to the illegal taxation of a civil right. This is the largest Second Amendment financial reckoning in history. The emergency ruling potentially invalidates every single training mandate in the country, a requirement currently enforced by states. We are analyzing mandates ranging from 2 hours, covering legal force and marksmanship, a hurdle cleared by white million Americans annually. These courses are a financial gatekeeper, with costs ranging from $dollars to over $dollars per applicant. But the Supreme Court has signaled that constitutional rights cannot be contingent on a competency exam. You do not pass a test to exercise free speech, nor do you pay for a course to claim Fourth Amendment privacy. If the Second Amendment is finally treated with the same strict scrutiny as other fundamental rights, mandatory training fails immediately. This creates a fracture within the community. While percent of owners value training, the legal reality is shifting from state-mandated coercion to voluntary responsibility. The government cannot demand you pay them to learn how to exercise a freedom you already possess. The battleground has now shifted to sensitive places, the legal loophole states use to ban carry even without permits. While the court accepts historical restrictions in courthouses or legislative buildings, modern bureaucrats have weaponized this concept to effectively nullify the right to carry. They have designated post offices, parks, transit, stadiums, and even entire city districts as sensitive, turning constitutional carry into a legal minefield. New York attempted to declare virtually all of Manhattan a no-go zone, while California tried to default ban carry on all private property. The emergency ruling explicitly rejects this expansive default prohibition. We are moving toward a drastic constriction of these zones back to their historical baseline: courthouses, prisons, and legislative chambers. Everything else becomes fair game. This is not just about permits. It is a total remapping of where American citizens can legally exist with their firearms. This creates a massive enforcement paradox regarding prohibited persons. Federal law bars felons, drug users, and the adjudicated mentally ill, approximately a million individuals, from possession. The permit system was the state's preemptive filter to catch these individuals before they could carry. Without that filter, states are forced into a reactive posture, relying solely on point-of-sale checks or post-incident arrests. Critics argue this eliminates preventive enforcement. Constitutionalists counter that the burden of proof is always on the state to prove prohibition, not on the citizen to prove innocence. But a prosecutorial trap is forming. If a prohibited person carries, are they charged with illegal carry or illegal possession? The distinction is often the difference between a misdemeanor and a felony. The ruling obliterates the permit question, but ignites a complex legal firestorm regarding how prohibition laws interact with a permitless society. The Supreme Court has fundamentally rewritten the rules of engagement for American gun rights. We are witnessing the collapse of a century of restriction and the chaotic birth of a new legal era. States are scrambling to salvage their regulatory regimes while millions of owners watch their rights expand in real time. Do not be the last to know how these changes affect your liberty. Subscribe now and stay ahead of the most significant Second Amendment transformation in history.